the first to know. Nsem-Pii TV.
President John Dramani Mahama is so wrong for the actions wateki against the Chief Justice. Gertrude Esaba Tukono. Gertrude Esaba Tukono. Ebusafo Kwabena Bomfe PhD and Dona friends Kabila Atnase in the studios of Peace FM. Wabra on the Kabna na ya okese Atnase na omu discuss na busafo say ensem ho His Excellency John Dramani Mahama we twa sabone ene ede ato ho ede kire enchirima say enchirima so ba sa esa na we twa to ho no eso musu edi so Kwabena Bomfe Kabila Atnase ede constitution no atoto ade a His Excellency John Dramani Mahama aye no ehunu say enye ne kwanso a o kire mu a abra sa petition we kopie mu ewo His Excellency na kachi no omu actual krata de command Supreme Court and say Supreme Court ne mfa nchire mu bi mra a Supreme Court ne bu omani egu so ena abiem so no sa committee a wote ya na eye poaman eda no ebusuafo na omusu ni emra bia eka ekova omu ho emomutimi tena sa committee ne eso na wode ensem bia asisi da president bia asisi sida ena de kire se sa de ya Article 146 His Excellency John Dramani Mahama ejina so no so wrong to the extent say and normal Chief Justice no no yentimi enyina so emfani nyimfiri office wa bra prima facie ewo ho a during the era of Kwame Nkrumah BBC AC ebusuafo me pese meka ni nyina ne nkuti abra Kabila de sa nsem nyina etudwa.
Consider it. A literal reading of the provision therefore could lead to the floodgates being open for frivolous and vexatious petitions being continuously filed against a serving Chief Justice, with 2 Supreme Court judges being perpetually tied down to hearing such petitions alongside the members of the committee that the president has to appoint. This is a scenario that would weaken the efficacy of the top echelon of the judiciary, and this is what President Mahama did. Dr. So
what was his remedy?
Was being prophetic.
What was his remedy for that lacuna?
And to say, there is even more mischief in a literal interpretation. This is because Article 14610A authorizes the president, albeit on the advice of the Council of State, to suspend the Chief Justice whilst a petition for his removal, in this case her removal, is being considered by a committee appointed by him under Article 1466. There is thus scope for the executive or others to initiate frivolous and vexatious petitions against the Chief Justice, resulting, according to the literal reading, to an automatic establishment of a committee to consider the petitions and the empowerment of the president to suspend the Chief Justice from his or her functions. This is a scenario that is deeply subversive of the balance of power underlying the 1992 Constitution and the separation of powers that it entrenches. It is, of course, also inimical to the independence of the judiciary, as the plaintiff points out in his statement of case. Oma issues are, and Obe can say, yeah, kai a constitution now. Yeah, you say, yeah, in fact, literal meaning nunkwa. And or can be real say. Article 1466 no yen wunu say say ye establish prima facie ti ewo Chief Justice there no ti say there 3 and 4 ye establish prima facie on any other justice of the Supreme Court. Samrei ye mungu ye nane no. There are 5 cases at the Supreme Court currently, including one led by census. I'm here, interested party.
Census,
Center for Citizenship, Constitutional and Electoral Systems.
Okay.
Challenging the constitutionality of the process. You can't say committee now, no man penisi wayen. Omun try so many years and because anytime can set up committee no crano. Supreme Court ya nyadwene. Almost say remedy anu ye na ye pe no. Committee no ebetimi aso ano. Ye di akire. The committee refused to address the issues that we raised because committee na ankasa no ya manu mrabia na guide no ono na choose CI 47 e the guide no ho again the Supreme Court in many judgments aka say article 146 committee no ese say ya manu nhihye ya odi be ye na dwuma cardinal enye ho adanse ani kwadu a yesi ye de elbo maame no yesi ni kunu ene ne ba ene ne tu kwan na judicial service ema ni kunu ene ne ba no sika ye de ho sobo ebo no emra ejina so de meti ai minim one ma ebusa se mra ben na sa process yi we call it a phony trial as a yesu ye pena kunu na Adamse for crime against Roman and Jewish law. I can say, ye dear same cry we are judgment baba not less than 48 hours. But the trial of Jesus Christ took any execution, it took less than 18 hours. 1 day crime. The NAIN. And then you friend kangaroo trial, kangaroo court.
Why will you make that conclusion?
I have made that conclusion because of the conclusion the president has come to. Notwithstanding challenges of the ill-informed process he was on.
When the 146 I can't say the recommendation about president ma onye ho hwe no.
You see, eno na ye ka say bibi hyase and say na koduru ba bia ye wo no. Enti enam saa sin tonunti ene ye ka say enam say sa committee owie na dwuma e cheche wo president wo santi. Say ahyase no ufum twa obefun ku. Anaso ufun bia ubefum atwa enti mfonso na dikan abade a yenso ano ne yensiesi kra asa na yato aso yesi hey yentiase ye manu nkoso ana yakoso ne yakowie se sesi ayi no asemu a eda court a enum and I can tell you ana no me ma me lawyers ema ye search wo court Supreme Court registry cardinal nukura wo mi say attorney general onye na dwene kura say obe file responses to statements ya file onye na dwene so obe me adu asem no obet ma file excuse say there's a legal vacation so time is not counted but asem he shall say June legal vacation shall say August June July 21 days na elapse enti bibia kire say ya dwene me trust you hana me kan say ade no de wa asi aye no now hwe say maame na nu ye ode come president echi president say we push a committee na committee no asemko pa o mukoko investigate kra no ana prima facie president establish here no on come yente enti okoso na omaye de oye no na it only concludes say ye see adwini pi ye wie de ye pese ye na mom ye pese ye ma na ye te se de ye de mra na ye sa pepe na wonim de ntia former chief justice Sofia Akufo ni buafu no
Debbie.
And at the I cost in the bonus. So, why yet what the 146 no in 2017-2018? What now committee swa or establish a prima facie?
Okay.
In the case of Mame Charlotte say,
okay.
George Nopokwa Mankwa, any Alaji Amadou
Sule.
Na me fa ne currency. Na ahobrasimu cardinal. Womo mudi Charlotte say dia ye twapia e de ye mfantu we no let me tell them Charlotte say started the process for her removal, prosecuted the process for her removal, and so she thought say no betimi ayi ni deputies no na ka ono nko she fell on her own dagger and I prove to you here.
Do
this is the file that I concluded on Amadou Sule nipa no dia ni mu no ye Emmanuel Kosi Senyo against Amadou Sule when madam say for mu ko ditia Amadou Sule
Debbie. Next time
PW1
train abotre next time oba me court has in as a exhibit here tender
mpacho me tender PW2 mpacho jima judge mami na on kanu modi no
mami hwe say a certified true copy
mpacho
till next time oba o the exhibit bi abana say
mpacho body no mami
PW2 Mrs. Charlotte Ama say
PW a petitioner's witness
Mrs. Charlotte Ama say She is the chairperson of the Electoral Commission, and she testified that in the last quarter of 2015, she received a request from the NDC party for the Electoral Commission to conduct its presidential and parliamentary primaries. She did minute the request to the respondent, the deputy chairperson in charge of operations.
That's Amadou Sule.
According to the witness, the NDC primaries were conducted on 21st November 2015. 2 days after the event, she reports that some of the staff of the Electoral Commission in the district were not paid monies due them from the primaries. She made inquiries from the Director of Finance, who informed her that he was not involved in the process in any way. The Director of Finance further informed her that his department did not receive the monies paid by the NDC and therefore would not be able to tell how much NDC paid to the Electoral Commission. The Director of Finance further informed her that he heard monies were paid to the respondent in his office late at night, and that electoral materials belonging to the Electoral Commission were taken from the stores unit of the Electoral Commission for the primaries, but the Electoral Commission had not been reimbursed. The witness said she decided to take up the matter with the respondent and the Director of Elections. The response she received from the respondent is in evidence as part of the exhibit attached to her witness statement and marked as C2. Exhibit C2 has a brief email from the respondent giving an account on the primaries and the budget drawn for the conduct of the NDC's primaries.
PW1, the page OIE before.
PW1, okay. PW1 wa henefa ntina on sentina me say yes wo bana web exhibitor na what tender but omo nyin koma no na document na baby o di PW1 na sha no 100
baby a ubie period
ma hu PW2 no but one no
kosoro
okay evidence of PW1
wo the body no kwa na ja dia kan man
Samuel opusu ampofu
enti omo a ejina amanyoko bi di mu a ya na omo ka se President Akufo-Addo ne ma ya pam Charlotte was any two deputies no chairman of the NDC at the time ekodi adanse si yem pam Amadou Sule on yame fa ne kransie me ma me George no poko amankwa da so te ase, and we have not been fair to them, because even what the state was due to pay them, I can say on authority say yem fam ma wono. But the point I'm making is say Charlotte say started the process for her removal. Unim said, notwithstanding this committee report, they are appointing it to board B. Contrary to the Public Office Holders Declaration Act 1998-550, Charlotte say is sitting on a public board. Contrary to that. Now let me come to the substantive matter at hand. Kadna, there you about Mame Tokonu no. President in chair say we establish prima facie to say there Mame Sofia Akufo odi kan establish prima facie wo ha petition e de ba ye no obobi guye eno hu de wanyina so eno odi committee no say committee no nkwohwe eno enye ho say now de de abono no kra no tie de Dr. Professor Dateba okaye ewo ajetun case no say the president and the council of state are not mere passive agents in the grave process, hallowed ground for the removal of the chief justice. Both the president and the chief justice are required by the ethos and foundation principles of the constitution and the central thematic purpose of Article 146 as a whole to establish a prima facie case prior to the appointment of a committee of inquiry. The president didn't do this, and he's failing to respond to the issues we have raised before the Supreme Court through the Attorney General. And you are saying, say, onye bonibia. Hey, na mua enra President Akufo-Addo process na ye file mu edi Charlotte say Amadou Sule any George Poko Amankwa ye yi wo mo dia na mo problem with it, and cry follow the constitutional process, because Chief Justice no establish prima facie as an establish committee no. No problem with it. No, mo say President Mahama, the why no from so be any they are pointing to the breach in law. Do you listen? Mutie. We say there are 5 cases at the Supreme Court prosecuted by lawyers of no mean repute. You think they haven't read the law? And they don't know what they are about? Yeah, who be the body? If anybody thinks that this matter is going to end with the removal as warranted by the president, now, your friend said, they to talk on the Obeko. But Ghana, your justice system, your constitution, your money per Kuobi and Messeno. Now, me person they conclude way. Or be a friend of KB Kwabena. The national security, the dilemma. Ghana national security, the dilemma.
Book now promise me now one farmer man.
Ya can kukwemu ya say ebeba.
Okay. I'm a padansi entra.
Ai, we the one for dance for the door. Oye Nkrumahist Chime. Ti the okafa Kwame Nkrumah for the removal of say Akokosa. I no cry no article 1960 constitution in Kaduna. Article 44. I man who kwan say Otimi Chief Justice Edi without going through some of these processes. No. Article 44. Or say 1, 2, 2 no say 3 no say the appointment of a judge as Chief Justice may at any time be revoked by the president by instrument under the presidential seal. 1960 Constitution Article 44 Clause 3. Or no who can say and go through that process ibia. And no one else on your share ya can say that be 79, no 69, 79, 92. There must be a prior process. Now apart from Chief Justice there no over Article 45 3 now or say any other judge no dear subject to the following provisions of this article, no person shall be removed from office as a judge of the Supreme Court or a judge of the High Court except by the President in issuance of a resolution of the National Assembly supported by the votes of not less than 2/3 of the members of Parliament and passed on the grounds of stated misbehavior or infirmity of body or mind. 1960 Constitution no isolate Chief Justice free other justices of the Supreme Court.
No,
so obey Chief Justice Adi since obey
other Supreme Court
justices of the Supreme Court. And no that about all kind constitution we no 1932 no can say and now if you know your phone one can system constitution there but there is 69 79 992 you know to me Chief Justice Adi for kwan so and any other justice of the Supreme Court. Dear KB Kwansen Kaye Nkrumah yi Sakoko said, don't say whatever it was. The direct intervention of the executive in the judiciary created its own security problems because significant sections of the bar and the bench plus significant sections of the public were not at all amused by the display of political muscle by the president in the judicial process. Many regarded that as the crucifixion of due process for political expediency. Kwame Nkrumah never recovered from that. Now, with humility, I must read this. Tell you them of you. President Mahama, you Mr. President, please, you are mine. Take heed. 1982, and I tell you them of you Trobuki. By Nkrumah's side, the labor and the wounds. the removal of Sir Akukosa had to do with the Kulungungu trial and the involved Tebi Adamafio.
Okay.
Nati Diokai. Page 139. Only one person in Ghana had power to order my arrest. That person was Dr. Kwame Nkrumah, the president, my staunch friend and leader. The man we had created by expert propaganda into a demigod. I had coined a deifying slogan: Nkrumah does no wrong, Nkrumah never dies. Now Providence was showing me how transient and futile was political power.